of Bo Dukes. But here's a look at some of that language in the text exchange on the phone of that friend. The two are talking about Grinstead's death, and the friend asks Bo who or what broke open the case after so long. Bo responds that Brooke, his girlfriend, let it slip to her mom. She tipped off the GBI through a long negotiation between Brooke, the case agent, myself, and eventually my lawyers and the district attorneys. We worked out a deal. Bo continues saying it worked out well for me at least, and Brooke may get the reward, that outstanding reward for information on Grinstead's death. This was at a time that it had been a cold case, but in 2017 he was questioned by those prosecutors and then arrested. Why this is important, the defense has been saying that there was some kind of incentive for Bo Dukes to actually come forward and say these things about Ryan Duke, his former friend and former roommate, and they say that these texts prove that, at least in his mind, there was some kind of benefit he expected to gain. Reporting in Irwin County, Georgia, Julia Janae with Court TV.
Our thanks to Julia. And again, that hearing will continue this afternoon. It's actually going to be conducted via Zoom as they wrap that up. And the judge makes the decision for all of the rules of the road, if you will, as they get set for trial. This is the final pretrial motions hearing in this case. Joining us now, retired federal prosecutor Robert Sanders. He's in New Haven, Connecticut, and criminal defense attorney April Prayer is in Chicago this morning. Good morning to both of you. Robert, this case is a bit convoluted in terms of the Duke and the Dukes, and they're going at it. Ryan Duke is now charged with the murder of Tara Grinstead. He and his defense team are trying to establish this idea that Bo Dukes told on his friend because he was given a deal by prosecutors, and the deal was, as long as you weren't part of the murder, we could work with you. The allegation is, okay, well, you told him that, and then he told you, oh, I wasn't a part of it, it was all Ryan. Your thoughts on whether this really matters in the grand scheme of things with all the other evidence piling up against Ryan Duke as they get ready for trial, or is this something worth fighting for if you're the defense?
Well, one thing about hanging out with criminals is that, you know, their criminality sometimes taints you. It taints your character. It taints what you say. Now, the defense wants to have that taint flow all over the witness. The government's going to have to come in and say, yes, you know, bad people hang out with bad people, and bad people tell each other things that they've done. Sometimes bad people help each other. And how far that goes, to the extent that the defense is able to raise that up and lay it out in front of the jury, tends to take away from an individual who recently took the fifth when asked questions. So, you know, that's an important aspect of this case, that one of the key witnesses has motive to say things that help the government, which potentially help himself.
Yeah, absolutely. And that was brought out during this pretrial motion hearing. To what extent the jury understands it and gets it, we'll have to wait and see. And you talk about the text messages that that are part of this, and Julia brought up one of them, and the defense is really honing in on that one text where he says, I thought we had a deal. There are some other texts, though, that sort of establish his same story, that he didn't actually kill Tara Grinstead. Here's an example of that. This is with an unnamed friend, and he says, he dumped her body in one of my family's orchards in Fitzgerald, and didn't tell me about it for blank days. Then I helped him get rid of the body. We were roommates at the time. And he's talking about Ryan Duke. April, these text messages go both ways. If there was no DNA on that glove, which put Ryan Duke at the crime scene, and there was no confession from Ryan Duke, this would be a different ballgame. But you add those two to the equation, it kind of, it looks like there's a pretty steep hill to climb.
There is. What's interesting is the role that text messages are playing in almost every trial these days. And so that will bear out in trial, and the jurors will decide which text messages they believe. But text messages have a lot of power because they're sent in the moment at the time. They're not sent at the time of trial. And so jurors can see what his state of mind was at the time. Yes, I had a deal, or I believed I had a deal. It even seems like money might have been a motivation. Hey, my girlfriend's going to get paid. It all worked out, and maybe we can split that pot. So it'll be interesting to see how it bears out, and what, we're still in the dark about what all of the text messages say. So it'll be interesting to see who those were sent to, when they were sent, what other messages were sent contemporaneously to those.
Yeah, absolutely. The details, who's he sending them to? This is another one that Bo Dukes sent to an unnamed friend. It said, dude, who else knew about this besides you? Bo responds, Emily, 2 guys from Osceola, Brooke, my cousin, possibly others I don't remember telling. Please, never bring a dead body. Bring me a dead body, although now I have some practice. Robert, to your point earlier, jurors are just going to be shaking their heads, saying, "Oh, both of you people are you're horrible." Does this move the ball at all? These text messages, or does it just sully everybody involved in this and will turn jurors off?
Well, so as I shook my head as you repeated what was said in those text messages, as I expect the jury to do as well, they're already sullied. Now, the dirt on one versus the dirt on another, the hands around the throat of a young woman by one versus another who then helped dispose of her dead body. When you talk about a killer and then you talk about the aftermath of the killing, can you separate those? Yes, you can. Can you separate them in this case when the person who is talking about the aftermath of the killing and pointing the finger is already serving a 30-year sentence? Yes, I think you can. I think the prosecution has the ability to not necessarily rejuvenate this witness who's being attacked right now in motions, but when he gets attacked on the stand, should he get to testify to all of this information in the regular merits of the case, they'll be able to say, yes, he's a nasty fellow, but he's a nasty fellow with relevant information from the inside because he was there.
Absolutely. And again, we'll have to wait and see if it plays out. If he actually testifies, he took the 5th during the pretrial motion hearings. We'll see what happens in May. Again, day 3 of those pretrial motion hearings expected to wrap up this afternoon in Osceola. Coming up, actor Jussie Smollett faces sentencing for faking a hate crime. We'll take you to the scene of it all. Go to Chicago next and talk about what we should expect will happen to Smollett. Will he talk? We'll find out.
At joincalibrate.com.
Former Empire actor Jussie Smollett is expected to be sentenced in a Chicago courtroom this afternoon after being convicted last year of staging a false hate crime. Court TV cameras are in Chicago. We'll bring you that sentencing live here on Court TV. The 39-year-old was found guilty in December on 5 counts of felony disorderly conduct for making false reports to police that he was the victim of a racist, homophobic hate crime back in 2019. Today, he faces a maximum 3-year sentence. However, the judge could release him on probation. Whether or not he decides to make a statement before sentencing could factor into the judge's decision, of course. Court TV legal correspondent Chanley Painter is in Chicago. She'll be in the courtroom for the sentencing, and she has a look at the scene at where the alleged staged attack took place.
We're here in downtown Chicago where Empire actor Jussie Smollett claims he was attacked by 2 men January 29, 2019 around 2 a.m. after he left this subway behind me, where he walked several blocks to grab a sandwich before returning to his apartment in this direction. Not far from the subway, the Osindaro brothers, who told the jury that Jussie Smollett paid them $3,500 to help him stage this attack and gave them $100 in supplies. They did a dry run where Jussie Smollett drove them around this area down the street, told the Osindaro brothers to meet him about a block away from the subway at that corner not far from Smollett's apartment. It was here on New Street in downtown Chicago, right at the end of the road where the alleged attack took place. Jussie Smollett told the jury that two men accosted him, yelled racial and homophobic slurs at him, punched him, kicked him, poured bleach on him, put a noose around his neck. The attack took place in about 45 seconds before those two men escaped. Jussie Smollett told police this. Police didn't believe him. The jury didn't believe him, and now he's about to be sentenced.
Still with us, federal prosecutor Robert Sanders in New Haven, Connecticut, and in Chicago, criminal defense attorney April Prayer. So, April, you're there. You've been living this. The whole country was very interested in this whole saga, but in Chicago, even more so. I can only imagine. What are your thoughts today in terms of the sentencing? He's facing potential prison time, but in a case like this, would he normally be sentenced just to probation? What are your thoughts on what will likely happen here?
I actually was present for every day of this trial at the courthouse, except for the times that the judge wouldn't allow the public in, which is an issue that they're going to argue today. We always jump the gun and jump to sentencing, but you have to do post-trial motions first. And my understanding is that the defense filed an 83-page post-trial motion that has to be argued before, and then the assumption is if they lose, then the Jussie will be sentenced. I've appeared in front of this judge, Judge Lynn, many times. I know him quite well. I would be very surprised if he gave Jussie prison time. He's still a first-time offender. As fantastical as the facts of this case are, he's still a first-time offender. And I also think that there would be some security issues if Jussie was sentenced to actually go to the Illinois Department of Corrections. So my guess is he would give him probation with a bunch of conditions and a super high fine.
Well, let me ask you this, April, since you were there during this trial, did you agree with the jury's verdict?
I did not, because I was able to see that the defense did more than just poke holes in the state's theory. They actually established a theory of their own, saying that the brothers that something nefarious went on with Chicago police, which is not that unusual, that the Chicago police put the brothers up in a hotel, which is quite unusual, and that Jussie might have actually been in the dark about what was going on. It's clear that he was attacked by the brothers, clear that the brothers had a scheme, but there were no text messages, nothing. There was no smoking gun to, in fact, that Jussie was in on this agreement.
Robert, this 82-page motion for a new trial brings up a lot of different arguments, that things that happen at trial. To that extent, should we assume that he's not going to say anything here, if indeed he is sentenced today, as April pointed out, after this is litigated? Pretty clear that he's got an appeal going, and he probably won't. He's not going to get up there and say, "I'm sorry, I did this." Right? Would that be your thought?
Yeah, I don't think he's going to go up with contrition in his mind or in his mouth. I think he's going to get up there and say, "I'm innocent. I was always innocent. This is a travesty." The most compelling thing I heard in that 83-page document, and oh no, by the way, the weight of the document doesn't establish its merit. The thing that I did hear was that there was an objection to a particular set of jurors that the judge did not allow to be fully vetted by the defense. In fact, shut the defense down when they had what appeared to me to be a legitimate a line of questioning to go down with a particular juror. Now, whether that is enough to cause for a mistrial from the judge who made the decision, I seriously doubt that. I don't think that's going to happen. But do I think he's going to spend time in prison? I agree with April on the security issues and the other things. And I also agree that a substantial fine will probably be imposed based on how the resources of the government were spent in following up this case. And first as an initial thought of a hate crime and then as a hoax. The last point is, I didn't watch the whole trial. I cannot dispute April's observations and what she said. But one thing that always stuck with me was when the police arrived at his house and somebody else was videotaping his interaction with the police, he still had that noose around his neck. I've been a black man in America all my life. And if somebody dragged me down the street, beat me up, put a noose around my neck, you know, one of the first things that would get off my neck would be that noose. And when the police showed up, it would have been on the floor, on the kitchen table, someplace else, but definitely not around my neck.
Yeah, and that was brought up during the trial. April, in the jury selection process, the judge asks the questions, apparently. We're used to watching the attorneys in voir dire here at Court TV. In most jurisdictions, the attorneys have that opportunity. With your dealings with this judge in that district, is that the way it goes, where as a defense attorney, you submit questions you want to the judge to ask potential jurors in voir dire? It seemed a little hazy, this description of it in the motion for a new trial. How does it work there?
Every judge is different. So in every courtroom we fight, obviously, because if nothing else, we want to build rapport with the jurors. And so some judges allow it. Some judges require that you submit all your questions in writing for them to read. Others will actually let you get up there and ask as many questions as you like. So this particular judge is extremely impatient and tries to be very efficient. And so he would cut all that out because of time constraints, if nothing else. And so in his courtroom, he asked all the questions, which obviously became a problem for both sides. It's also a problem that none of the public was allowed in for voir dire, so you don't have any actual witness accounts of what took place in voir dire other than the court staff and the attorneys who were there to litigate.
Interesting. Yeah. Okay. So it's up to the individual judges, and our viewers have seen the odd impatient judge here on Court TV. That makes sense. We get it. Robert, is this an issue, do you think, that has legs? And if this was a murder case or the consequences were higher, this would be a different ballgame. This is, you know, it's not, I wouldn't say, I guess, low level, but fairly low level in the grand scheme of things. When you factor all of that in, first of all, are you surprised this ever even went to trial? And two, appellate-wise, does it matter?
Well, I'm not surprised that it went to trial. Once the government, the prosecutors, the police all came to one mind that this was a hoax perpetrated on them as a publicity stunt for an actor who was on the tail end of one piece of his career trying to revive or jumpstart another part by this type of activity, not surprised that it went to trial. Now, is it a minor thing? Well, you know, justice denied is always a problem, no matter on what scale. And the merits, before we get to the merits, we should always be looking at why. Why are we here? What is the point? Well, the point here is to not, for the government, for the prosecutors, for the police, to not have copycats, to not have people use public resources in this manner. And for the next person, this is a warning to find another way to promote yourself.
Yeah. Unless April's right and it was the Osundaro brothers, then it's a message, hey, you could set your buddy up and you might get away with it. We're going to step aside, take a break. Again, that sentencing set for 2 o'clock Eastern, 1 o'clock Central Time, and our cameras are going to be in the courtroom, and we'll watch it together play out. Coming up, the murder trial for former Ohio Dr. William Husel continuing this morning. There he is with his high-profile lawyer, Jose Baez. We'll take you into live testimony as soon as they get up and running in Ohio. That's next.
He was given doses just 20 minutes earlier that would take down an elephant, and they had not had the full effect because the drugs are still increasing in their effect on the body at that time. So the amount of impact of stopping breathing is growing inside his body at the time that he's then given a double dose even more.
Day 12 in the murder trial of former Dr. William Husel set to begin in just a few moments. Apparently, the parties are in chambers. The state is expected to recall Dr. Wes Ely, that individual you just saw right there. He's an expert on crisis and end-of-life care from Vanderbilt University. Jurors in the trial have heard testimony from dozens of witnesses, people who worked at Mount Carmel Hospital there in Ohio and worked closely with Dr. Husel during the time that he prescribed painkillers that prosecutors say killed his patients. He's now charged in the death of 14 of those patients who were under his care over a 3-year period. He's pled not guilty to all of the charges. On Wednesday, former ICU nurse Stephanie Letcher testified to working with her first palliative care patient, Sandra Castle, and questioning the amount of drugs that Dr. Husel asked her to administer.
Were you familiar at the time with the equa-analgesic equivalency of morphine to fentanyl?
No.
Are you aware of that now?
Yes.
All right. So she's going from 10 milligrams of morphine to 1,000 micrograms of fentanyl. Do you recall her? I'm transitioning here, Judge.
Let's re-ask.
She was on how much morphine?
10 milligrams.
And then Dr. Husel orders how much fentanyl?
1,000 micrograms.
Do you recall the amount of midazolam, or if she was on any type of benzodiazepine as part of that 10 milligrams of morphine?
I know she had gotten it in the past, but I didn't give her any prior to that.
So she's not even on a benzo, to your recollection?
To my recollection, I don't remember.
And how much midazolam did he order?
10.
And this is outside this is outside the room, outside where the family is?
Correct.
Okay. How did you take it you were supposed to withdraw that medication from Texas?
To grab it now.
Okay. And to grab it now, how do you have to do it?
Override.
All right. What happens next? Are there any other nurses or other personnel around you as you receive this order?
Yes. Tyler Rudman, who was a nurse on our floor and also a nurse practitioner student, was around, and I had asked him just if this was like a normal palliative dose, because this was my first palliative patient. So.
Tyler Rudman?
Correct.
When you say there was Tyler Rudman was around, also a nurse practitioner student, are you talking about the same person, or is there another person there who was a nurse practitioner student?
The same person.
All right, still with us, retired federal prosecutor Robert Sanders in New Haven, Connecticut, and criminal defense attorney April Prayer in Chicago. Robert, this case is, you just heard it in those sound bites, a lot of technical terms, 14 alleged victims. It's complicated. It's complicated to the point where it could, does it work one way or another, the complication, the inherent complication of a case like this? Does it benefit one side more than the other, in your opinion?
Complication benefits the defense. It's the prosecution's job to cut through the chaff and all of the smoke and the clouds to the straight and narrow and the lining behind all of that, where the members of the jury can see clearly what is actually written on the wall. And in this case, the defense is saying that the doctor was essentially incompetent in his job. I mean, that's how I hear it. So it was either intentionality in the dosages to these, not 1, not 2, not 3, but 14 patients as charged, or incompetence at a very, very high level.
And April, go ahead, Robert.
Yeah, now either way, that paints a very bad picture of the doctor, but does it allow for him to be criminally convicted at the level of incompetence?
Isn't, April, that the only way out of this, though? Because if you say, yeah, he knew what he was doing, but he wanted to help these people as they were dying, he wanted them to not feel any pain. Morally, you can take his side. Jurors may be touched by that, but you can't do that, right? You can't be that person. You can't say, okay, it's time for them to die now, and we're going to do it my way. That's just not legal. So they're in a tough position, are they not? Because they're saying that he was trying to ease their pain. He didn't think it would kill them. But to Robert's point, well, you didn't think it would kill him, really? After 10, 11, 12, 13 of them died within minutes of this, now you become incompetent. What's your take on on just this trial overall and all of the different issues that come into mind for these jurors they're going to have to deal with?
I think it's a fascinating trial because I really think that if it but for the number of patients who died, this would be a civil matter only, and it would be a matter for the medical board to address. Because what is clear through all of the witnesses is that there's no standard amount. Like, there's nothing fixed saying you cannot go over 50 milligrams of fentanyl or what you do is criminal. What they say is it has to be in good faith. And remember, this doctor is an expert himself, who I'm sure will take the stand. So it becomes the battle of the experts. Who do you trust? Who do you believe? He has all these people in his corner, including a lot of the prosecution witnesses, end up saying something helpful for the doctor at the end. One of the witnesses, I believe yesterday, said, I think it's unfair to judge a doctor because this is what I do for my practice. That is what he did for his. So I think it's very muddy, and I don't know if it reaches the level of criminality. And again, that will be the state's burden. So yes, it's a very complicated case, and it will come down to which experts the jurors trust and believe. And included in that is this defendant is also a very well-liked, very well-respected expert as well.
Yeah, and to your point, April, during the opening statements, Jose Baez, who's representing Dr. Husel, basically put the whole healthcare system on trial and said that, yeah, he was one person in many, and there were so many issues. And yesterday, Tyler Springer took the stand. He was an ICU nurse, and his testimony on some levels helped the defense. At one point, he said, I really respect Dr. Husel. He's a really nice guy. And at one point also, he indicated that he gave a dose of medication, and he didn't know that this patient had already received a dose just minutes before. Take a listen.
So the fentanyl, the Dilaudid, and the Versed, all together for Mr. Hayes?
Yes.
Are you aware of whether or not Mr. Rudman had administered those exact same doses to Mr. Hayes about 20 minutes earlier?
I was not.
What did you do at this point? You were given these orders.
I would draw the medication up and go and give the medication to the patient.
Okay, so you withdraw from where?
From the Pyxis.
And do you remember whether you awaited for approval from the pharmacy or did this via an override?
Override.
And then once you withdrew this medication, what did you do?
I went to my room, obviously got the verbal order. We put the order in. Actually, we put the order in, overrode, and then I got the medication out and went and administered to the patient.
To Mr. Hayes?
Yes.
Was Mr. Hayes already extubated at this time?
Yes.
So that was done prior to you arriving in the room?
Yes.
Was there any family there at that point?
I believe the son was there.
And you said you got the order. Who did you get the order from?
Dr. Husel.
Robert Sanders, that story went on cross. It was revealed that the son was there. Yes, the son had driven up from North Carolina and got to the hospital and said, pull him off life support. And there was acrimony between son and dying dad. And that's when Husel gives him the 1,000 micrograms of fentanyl after they took him off life support. At the end of the day, Robert, if he says, yes, all right, these people were about to die, and I really wanted them to die with no pain, so I gave them these elevated levels of fentanyl, not knowing that they were going to die anyway, maybe it would increase or decrease the time, but they were going to die, and they were going to die pain-free. Is that fine? Is that legal? Can he get away with that? Or does he have to say, I had no idea it could kill him?
Whatever the doctor's rationale at the end of the day, he gave the medicine. First thing is, was that the right thing to do in our society? Well, we as a society have not supported across the board assisted suicide. It's still a contentious matter, whether it be doctor assisted or otherwise. And when you say to have a pain-free death, well, first, did they desire to die? Did they want to fight to live, even though it was going to be painful? Second, a pain-free death. Well, the difference between a pain-free death and a comatose death are two different things. Are you able to be awake and engage with your family members as you leave this world for the next? Is that a desire? Is the doctor interrupting that desire of the patient? Does the patient still is competent to make those decisions about their own life? Yes, I want to be awake. I want to engage my family. I understand it would be painful. Now, the doctor doesn't get to make those decisions. Other people get to make those decisions. The doctor gets to advise. He gets to help, but he doesn't get to make the decision.
Yeah, all right, well said. Let's do this. I'm going to break in here. We are anticipating the testimony will resume at any moment in Ohio, and when it does, we're expecting to hear from more former ICU nurses. In fact, we're going to start likely with the cross-examination of this woman, former ICU nurse that testified yesterday. That's next. Stay with us.
% off shopguilt.com today.
Welcome back. The judge in the Huesel case just came into the courtroom and declared that after meeting in chambers, there's going to be about a 10-minute delay. So we'll get you live in for testimony as soon as they get up and running in Ohio. Fentanyl, morphine, and diazepam. Those are just some of the medications that Dr. Huesel is accused of using in his cocktail of pain-killing drugs for his patients. Jurors in the trial will have to weigh whether Huesel was simply trying to ease the pain of his chronically ill patients that were near death or acted with malice when he prescribed these drugs in what his colleagues have referred to as, quote, extremely high doses. We just heard from former ICU nurse Stephanie Lachard, who recalled working a night shift with the defendant in 2018, where she cared for one of Huesel's patients. On cross-examination, which did take place yesterday afternoon, she was questioned about an issue at the crux of this case. Was Huesel just following orders from the families, or was he making this up on his own? Take a listen.
In your entire time as a nurse, both at the Cleveland Clinic and at Mount Carmel, has a doctor ever told you when ordering medication, get me 1, 2, 3 vials, give the patient 3 vials of medication?
No.
Right. So it's never done by vials, right? It's done by either milligrams or micrograms or